Business law obligation contract. Article 1262. An obligation which consists in the delivery of a determined thing shall be extinguished if it should be lost or destroyed without the fault of the debtor and before the delay was made. So, when by law or stipulation, the obligor is liable even for fortuitous events, the loss of the thing does not extinguish the obligation, and he shall be responsible for damages. The same rule applies when the nature of the obligation requires assumptions of risk. Example: Justin promised to deliver 100 cans of rice to Mrs. Montero, but the rice Justin intended to deliver was washed by the flood. Justin is liable to Mrs. Montero because his obligation is to deliver a generic thing, and it is still be paid from other sources if it was lost or destroyed. The rice to be delivered is confirmed to a particular class and may thus be considered a determinate thing. Article 1263. In an obligation to deliver a generic thing, the loss or destruction of anything of the same kind of does not extinguish the obligation. This article based from the principle that genus never perish. The debtor can still be compelled to deliver a thing of the same kind. The creditor, however, cannot demand a thing superior quality, neither that a debtor deliver a thing of inferior quality. If a generic thing is delimited, that is where there has been limitation of the generic object to the particular group of things. The obligation is extinguished by the loss of the particular group from which the prestation has to be taken. So, example: Nathaniel obliged himself to deliver to me a specific racehorse. The horse got a permanent injury. The partial loss is so important to extinguish the obligation. If the loss is due to the fault of Nathaniel, he is obliged to pay the value of the horse with indemnity for damages. If the horse to delivered is robbed, slaughtered. Article 1264. Effect of partial loss of a specific thing. The article establishes a disputable presumption of fault whenever the thing to be delivered is lost in the possession of the debtor. The presumption is reasonable because the debtor who has the custody or care of the thing can easily explain the circumstances of the loss. So, Article 1264. For example, Mark is obliged himself to deliver to Jake a specific race horse. The horse met an accident as a result of which he suffered a broken leg. The injury is permanent. Here the partial loss is so important as to extinguish the obligation. If the loss is due to the fault of James, he shall oblige to pay the value of the horse with indemnity or for damages. If the horse to be delivered is to be slaughtered by Jake, the injury is clearly not important even if there was fault on the part of James. He can still deliver the horse with liability for damages if any suffered by Jake. Example: Isa borrowed Anton's car on the due date of obligation. She told Anton that the car was stolen and that it was her fault. That is not enough to extinguish her obligation. It is presumed that the loss was Isa's fault, hence she is liable unless she prove contrary. Suppose that my house was destroyed by accident in a fire and the car was in the house. When it occurred, I am not liable unless Isa proves fault on my part. That's all. Thank you.